Hi, everyone. Welcome to our webinar. So today we'll discuss the role of cities and regions on the implementation and enforcement of environmental law. I'm Anais Berthier. I'm the head of EU affairs at ClientEarth. So maybe I'll just say first a few words to present the organization. ClientEarth is a European public interest law organization. So the specificity of this environmental NGO is that it's almost exclusively composed of lawyers. So we really use the law both in our advocacy work, but also, of course, bring litigation both at national and European level before the Court of Justice of the EU. We have offices in London, Brussels, Madrid, Berlin, Warsaw, Beijing, and Los Angeles. We're around a bit more 200 staff now, and have different programs. So working on climate, energy, forest, trade, environmental democracy, air quality, biodiversity. And so today we would like to discuss, as I said, the role of cities and the role of the regions in the implementation and enforcement of environmental legislation. Cities, but also regions, are major stakeholders in the implementation of the law and are sometimes or always at the forefront of actually what needs to be done in terms of environmental protection. Some of them even go further than what the law requires, and we'll see that it sometimes puts them into a difficult situation, including before the courts. We'll have the opportunity to discuss that in discussing important cases that have been brought before the Court of Justice of the EU, brought by cities, but also by regions today. And so I think it's fair to say that cities and regions are really becoming real environmental watchdogs along environmental NGOs today. And that is really welcome because the lack of implementation and enforcement of environmental legislation is still one of the main issues we face today, and that prevents from having the right level of environmental protection. So we'll have the opportunity to discuss first the general conditions of access for the members of the public and NGOs to the Court of Justice of the EU, conditions and opportunities that are unfortunately very slim for NGOs still today, since the court has adopted a very, very restrictive interpretations of the conditions that have to be fulfilled to have legal standing before the Court of Justice, to be able to challenge decisions of European institutions. And such a restrictive interpretations that actually environmental NGOs still don't have legal standing today under the treaty because of that restrictive interpretation. They have more opportunities under the Aarhus regulation that implements the provisions of the Aarhus Conventions to the European institutions. This regulation is being revised exactly to put it in line with the Aarhus Convention. And so Friel will take us through this process and that issue. We'll also discuss the recent ruling adopted by the Court of Justice of the EU in the case brought by the Brussels Capital Region, ruling that has been adopted really recently on the 3rd of December. And so Antoine Bailleux, who represented the region in that case, will tell us about that ruling as well. And finally, we'll hear from C40, a network of cities. And Georgina Short will give us a more general overview and a reflection on the role that cities are already playing in the implementation and enforcement of environmental legislation around the world, not only in the EU. So for once, we will have an interest and see what's also happening beyond the EU, and see what role the cities are already playing and are considering playing in the future as well. So first we'll hear from Anne. Anne Friel is a lawyer at ClientEarth. She is leading our environmental democracy work, the environmental democracy program focuses on the implementation to improve, actually, to ensure better implementation and enforcement of the provisions of the Aarhus Convention, both at national and EU level. So Anne, the floor is yours.
Thank you, Anais. Capucine, could you put up my my presentation? There it is. Okay. So yes, my presentation is going to focus on access to the EU courts. So as we know, cities and regions have to implement a multitude of EU decisions taken by the EU institutions and ensure their compliance within their territory. So they have a particular interest in ensuring that these EU decisions are lawful in themselves. And one very effective means of doing this is to be able to challenge such decisions before the EU courts, before an unlawful decision has a negative impact on the environment and on the health of the citizens that these cities and regions represent. So I'm going to take you through the different ways and means of bringing cases directly before the Court of Justice to challenge decisions of EU institutions. And I'm going to set this in the broader context of the access rights of the public in general. So of individuals, of companies, of NGOs, and of course of cities and regions. So when it comes to the EU courts, there are three possible routes to the Court of Justice. You can firstly bring a direct action for annulment under Article 263 of the Treaty on the Functioning of the European Union. The second way is to bring a case in a national court and then ask the national court to refer a question on the validity of an EU decision under Article 267. And the third route, which is only available for NGOs, so here it wouldn't be available for cities and, well, it's questionable. It's under the Aarhus regulation, it's only available for NGOs, is to bring a request for internal review of an EU decision, which is an administrative review procedure with a possible appeal to the General Court of the EU. So before I go through these three different routes in turn, I'm just going to set out these EU rules in their wider context under international environmental law. Because the EU and all of its member states signed and ratified the Aarhus Convention, which is an international treaty that provides specific rights to the public to have access to the procedures that would allow them to protect the environment. So Article 9 deals with access to justice, and it specifically states that members of the public must have access to administrative or judicial procedures to challenge acts and omissions by private and public authorities which contravene provisions of national law, or in the case of the EU law relating to the environment. Article 9.4 then guarantees that these procedures must provide adequate and effective remedies, including injunctive relief, and that they must be fair, equitable, timely, and not prohibitively expensive. So I'm just setting this out here because back in 2008, ClientEarth looked at the different ways of coming before the Court of Justice in environmental matters and decided that they did not comply with the convention. And they brought a communication to the Compliance Committee of the convention, alleging that the EU is in breach of these access to justice provisions. And in 2017, the Aarhus Convention Compliance Committee indeed found the EU to be in breach of these provisions. So now I'm just going to take you through the different means, and then I'll come back to what's happening about that compliance decision later on in my presentation. So first, let's take a look at Article 263 of the Treaty on the Functioning of the European Union, which, first of all, it allows the member states and the institutions to bring actions for annulment of EU decisions before the Court of Justice, and they don't have to show any, there are no criteria that must be fulfilled by these applicants, the member states and the institutions, to have access to this procedure. They're called privileged applicants. But for everyone else, and that includes the public authorities of member states like cities and regions, we have to show that we fulfill the standing criteria. So first of all, if an act is addressed specifically to you, that's enough. You can go directly and challenge that act before the court, before the general court. And that would be the case, for example, if you request access to an EU document, the decision on perhaps refusing access to a document is addressed specifically to you, and therefore you can challenge that decision before the Court of Justice fairly easily. For all other decisions, you have to fulfill the standing criteria that are laid out in Article 263. So the first stage is that you need to show that the act that you want to challenge is of direct and individual concern to you. And the Court of Justice back in 1963 handed down its judgment in the Plowman case, and this is effectively still the test for individual and direct concern today. And there are extremely stringent requirements to fulfill these criteria. So if we look at individual concern first, this really poses the greatest problem to bringing cases before the Court of Justice, because you have to show that the act that you are challenging affects you by reasons of characteristics that are particular or peculiar to you, or circumstances which kind of single you out individually. So obviously, when it comes to challenging acts that breach environmental law and that impact the environment, it's very difficult to meet this criteria, because usually we want to challenge these acts because they affect many individuals, and they have a negative impact on all of the individuals living in a particular area where the environmental harm is happening. Secondly, you have to show direct concern, and the court has interpreted this to mean that you have to show that your legal situation will be changed by the act that you want to challenge. Again, in the environmental context, this is also a very difficult criterion to meet, because generally, for example, for NGOs, usually our legal situation will not be impacted by a measure that affects the environment. We want to challenge the measure because on the basis of environmental protection, not because our legal kind of rights are affected. And as we'll see in the cases to be discussed that were brought by cities and regions, this criterion can be very difficult for cities and regions to fulfill as well. Anyway, moving on to this kind of third limb of Article 263, back when the Lisbon Treaty was being negotiated, it was the negotiators took into account the fact that the standing criteria set in the Plowman test was so strict that, in fact, in some situations, some EU decisions could only be challenged if the applicant had actually breached the law and was being pursued by national authorities for not having complied with EU law. So it was realized that this was not a very good situation. And so they brought in this third test that was supposed to ease the requirements for certain EU measures, non-legislative EU measures. And for these measures that do not entail national implementing measures, you need to show that you have been directly concerned, so you don't have to show individual concern. Again, though, this hasn't made a great difference for environmental NGOs, since we almost never meet the direct concern criterion, and also it's still very difficult for cities and regions. So the consequences of applying these tests in environmental cases is that no individual or NGO has ever been able to challenge a decision directly before the EU courts in order to protect the environment. And as a result, the Compliance Committee of the Aarhus Convention found the EU to be in breach of Article 9.3. And I'm just going to take a look at what the Compliance Committee said. They basically, realized that the direct concern criterion, even for acts, regulatory acts that do not entail implementing measures, that even the direct concern criterion was still impossible for NGOs, members of the public, to overcome. And also they found that there was no basis in the convention for excluding acts that require implementing measures from review. And now I'm just going to have a look very briefly, because these, at least one of these cases will be looked at in a lot of detail by Professor Bailleux in his presentation. But I just want to have a look at two recent cases where cities and regions applied to the General Court under Article 263. And these are two very contrasting judgments. So the first one came when the cities of Paris, Brussels, and Madrid applied to the court for the annulment of an EU regulation that regulates the emissions tests for light passenger and commercial vehicles. So while this regulation specifically kind of brought in real driving tests to ensure that there can be no cheating in laboratory tests on emissions, it also kind of weakened one of the standards for new vehicles for a certain amount of time. And the cities wanted to challenge this kind of weakening of the standard. And they argued that they were directly concerned by this measure because, in fact, it impacted on their powers to regulate the circulation of cars that meet this Euro 6 standard. And the court and the General Court actually agreed with that. They found that indeed they based themselves on case law that said that an EU measure that affects the powers of a public authority to set rules in the way that they see fit has direct concerns them directly, and therefore they gave the cities standing, and in the end they actually upheld their case and annulled the regulation. This case is currently under appeal, pending before the Court of Justice. And this is in sharp contrast to the case brought by the region of Brussels to challenge a Commission regulation that renewed the authorization of the active substance glyphosate, which can be found in many, many, many pesticides. And in some ways, the region of Brussels, I won't go into too much detail on this case because it will be discussed in great detail next, but just very quickly to show the contrast, the region argued that indeed they also have powers to regulate the use of pesticides on their territory, and that this the renewal of the authorization had an impact on those powers. But the General Court did not agree with them on that. And this was upheld by the Court of Justice just at the beginning of this month. And that will be discussed in greater detail. So you can see that direct concern is still not a given for cities and regions, and it can still be a criterion that's very difficult to satisfy and that is keeping them out of the Court of Justice. Moving on to the second route that I spoke about, and to be able to challenge EU acts that contravene environmental law. This would be the route of, first of all, challenging a national implementing measure in a national court, and then asking the national court to refer a question to the Court of Justice of the EU on the validity of the EU Act, which is the source of the National Implementing Act. So I first of all want to start off by saying, and this is a quote from Craig and de Burca, that Article 267 and the criminally referenced procedure in general is the jewel in the crown of the Court of Justice jurisdiction. because it has allowed the court to ensure a consistent interpretation of EU law throughout the member states. And we would certainly agree with that, and particularly in the context of access to justice at national level, the court's jurisprudence under Article 267 in these preliminary questions has been really transformative in ensuring access to national courts in environmental matters. However, when it comes to using this procedure to challenge the validity of EU acts, it is a very long and winding road that really does mean that it's certainly not as effective as being able to go directly before the Court of Justice, for example, under Article 263. I mean, one of the big problems that we face in using this is that standing in environmental matters for in national courts is not always a given. We still encounter many problems in accessing national courts. And of course, if you can't access a national court to begin with, you can't have a preliminary reference. Second of all, there are all sorts of practical barriers as well to accessing national courts. It's not just a question of legal standing. There can also be prohibitive costs, for example, in quite a few member states. It's extremely costly to bring a case in a national court. Then the applicant obviously doesn't influence whether the national judge decides to refer a question or not, and we also don't have any influence over the formulation of the questions that they do refer. And of course, fourthly, it leads to really very long delays in the procedure. So it means quite often that an unlawful EU act, by the time it comes before the Court of Justice, it would have already had negative impacts on the environment. So very quickly, we brought these arguments to the Compliance Committee of the Aarhus Convention in our communication, and the Compliance Committee also found that indeed, while Article 267 is extremely valuable in ensuring the consistent application and implementation of EU law, it's not adequate means of having access to justice within the meaning of Article 9.3 of the Aarhus Convention. Finally, so the third way of bringing kind of environmental cases before the Court of Justice, which is open only to NGOs, is through the Aarhus regulation. And this regulation was adopted after the EU had ratified the Aarhus Convention, specifically to provide another means for NGOs to be able to challenge EU acts that contravene environmental law. So the way that this works in practice is that an EU institution or body will adopt an administrative act. So this is a non-legislative act, or perhaps that they fail to adopt an act that they should by law. So within 6 weeks of the adoption of the act or the failure, an NGO can then ask the EU institution to re-examine its own decision on the basis that it contravenes environmental law. So there are two possible outcomes to this. First of all, the EU institution might, it's never happened in practice, but they might accept the arguments brought by the NGO and agree to re-examine its decision and alter it in certain ways. But what has happened up to now is that the EU institution in question will provide a negative decision. Will say basically that they don't accept the arguments of the NGO and that they're not going to reopen their decision. And then that review decision can then be challenged before the EU General Court on the basis of Article 263. So this sounds very good, but actually in practice at the moment, the internal review procedure just is unworkable. It doesn't work because the definition of the acts that can be subject to internal review is so narrow. So at the moment, it only applies to acts of individual scope, and that's been interpreted as meaning that it only is available for acts that are addressed to a specific individual, usually a company. And it must be shown that this act was adopted under environmental law. And this is really problematic because this is not in line with the convention. The convention says that any act or omission must be reviewable on the basis that it breaches environmental law. But the act itself does not have to be specifically related to the environment. So, for example, it could be a financing decision that breaches environmental law, although it wasn't adopted under kind of the competence that deals with environmental law. And at the moment, we also have to show that the Act is legally binding and has external effects. And this has been interpreted also very narrowly by the EU institutions up to now to ensure that we can't ask for the review of what they would call an internal act, even though the effects of that act, it can have clear effects on the environment. In addition to this, there's a kind of an arbitrary exclusion for certain decisions of the EU institutions that when they act in a kind of administrative review capacity. So, for example, when they are looking at the lawfulness of a national state aid that's been notified to it, and we argued that these exclusions have no basis in the Aarhus Convention and therefore in breach. And finally, there's also some problems in relation to this procedure because obviously when you ask an EU institution to review its own decision, there's that decision is usually partial. It's not independent. But then when you actually ask the court to review that, so the court is obviously an independent, gives an independent review, but it can only review the lawfulness of the review decision and not of the underlying EU act that actually gave rise to the internal review in the first place. And this means that the remedies that that the court is able to hand down, there's a question over whether they are adequate and effective. So again, the Compliance Committee also found that, yes, the acts that are subject to review under internal review are far too narrow to comply with Article 9.3. And they also raised the problem of effective remedies, although there had been no examples, there'd been no case law on it yet. So back in 2017, it was unclear how the court would kind of interpret its jurisdiction under the internal review procedure. So it kind of gave directions, well, it gave a recommendation to the EU on how it should deal with that. And here it is. So the Compliance Committee found that neither the jurisprudence of the court under Article 263 and Article 267, nor the Aarhus regulation provide access to justice to members of the public for the purpose of the convention. And they recommended to amend the Aarhus regulation, so to ensure that the scope of acts that can be reviewed is much wider, and interpret the provisions of the treaty in compliance with the convention and its own case law. In compliance with the convention and its own case law and access to justice at national level, where the court has been really active in ensuring that the national courts must comply with the convention. So when the Compliance Committee adopts a finding of non-compliance, these decisions of the Compliance Committee must then be endorsed by the members, by the parties to the convention at the meeting of the parties that happens once every 4 years. And in this case, this was the first time that the meeting of the parties was unable to endorse the findings of the Compliance Committee, because there was kind of a very strong reluctance on the part of the EU institutions to do that. And so a compromise was found at the last meeting of the parties to kind of delay a decision. And in the meantime, the EU committed to explore ways and means of bringing EU law into line with the convention. So this has been happening. I think the Council of the EU particularly took the initiative to use the Article 241 procedure, which means that they can ask the Commission to come forward with a legislative proposal. So first they asked the Commission to explore how the EU could come into line with the Convention within the confines of the treaties. And if appropriate, to bring forward a legislative proposal. So that was done by the Commission, and in October they did publish a proposal to amend the Aarhus regulation to bring it into line with the Convention. And in parallel, the Commission asked the Compliance Committee to have a look at its proposal and to provide its advice on whether it really does its job of bringing the EU into compliance with the Aarhus Convention. And that advice is due to be handed down any day now, and hopefully before the end of the year. So I'll just talk very quickly about what the Commission's proposal actually does and what it changes. So it does actually provide a new definition for the administrative acts that can be subject to review under internal review. And very importantly, it says that administrative act means any non-legislative act adopted by a union institution or body. So just talking about that first part, it's very important to note that they've taken away that criterion that acts must be of individual scope. So it should in principle apply to all non-legislative acts of general scope, which is very important, because obviously it's these acts that have these acts of general scope that have the greatest impact on the environment, and that NGOs really have an interest in challenging. It's also removed the criterion that the EU Act must be adopted under environmental law, so that ensures that any act which contravenes environmental law is reviewable. Unfortunately, though, there are still some loopholes. So the Commission chose to keep this wording and this requirement that an act must have external effects, which we find very problematic, because the Compliance Committee has been very clear that this doesn't comply with the Convention. And we know that it has been open to misinterpretation by EU institutions in the past, just to escape review of certain acts. But probably what's the most problematic thing about this new definition is that they have inserted a new requirement that to be reviewable, an act must not, I'll phrase that differently, that provisions of acts for which implementing measures are necessary are not reviewable. So this is very, very problematic, because the vast majority of EU acts have to be implemented at some point by a national level. And the way that this is worded, we fear, really opens that up to an interpretation that would exclude very many EU acts from review under the Aarhus regulation. So I think if I try to give you an example, the kind of thing that we are worried about is that if we use the example that Professor Bailleux will go on to talk about in his case, the EU Act that authorises the active substance in pesticides. That authorization is in some way implemented at national level, because it's national authorities that take the decision on whether to authorize pesticide products that contain that active substance. So we would be worried, for example, that these acts would then be excluded from internal review, and that we would have to go through the preliminary reference procedure to be able to have a review of that that Commission decision that authorises the active substance glyphosate. And that we feel is quite clearly in breach of the Convention, and it's clearly in breach of the findings of the Compliance Committee. So we're really hoping that now that this legislative proposal is being discussed in the European Parliament and in the Council, that these loopholes will be identified and closed in the legislative procedure through amendments. So this is actually a slide just summarising what I have just explained to you on the strengths and weaknesses of the Commission's proposal that's currently under discussion in the EU legislative procedure. So just to conclude on access to justice public to the EU courts, the Aarhus Convention, which is accompanied by a strong compliance mechanism, unusually for an international treaty, really has proved extremely useful, and it's shown that the Compliance Committee has teeth. This whole procedure from start to finish since 2008 has showed us that it's really important to ensure that all of the parties involved in a communication really understand the findings of the Compliance Committee, and that they understand what the ramifications are for the EU. And this led to really most of the EU institutions at least acknowledging the lack of access to justice and pushing for greater access, and it's led to the revision of the EU Aarhus regulation. And we just hope that this will really bring the improvements that are so badly needed for access to justice. And that concludes my presentation. So feel free to put any questions in the chat. And I will pass back to Anais. Yeah.
Thanks a lot, Anne, for that really clear and great presentation. So yeah, definitely, I think that we can say that this whole process before the Aarhus Convention Compliance Committee proves that the committee has teeth, since they did recognize the EU in violation of the Aarhus Convention. And it is really thanks to that process and thanks to these findings that the European Commission finally decided to revise the EU regulation, so the Aarhus regulation that implements the Aarhus Convention. So in the end, even if it was a really long and process, and that of course a lot of advocacy work had to be done to really convince the European Commission to act, it proved to be impactful. Unfortunately, there are still, as you said, quite some resistance, loopholes, resistance from the European institutions to really adopt the necessary measures to really bring actually EU law in compliance with the Aarhus Convention. That is still not the case according to us. So if the proposal was adopted as such, unfortunately, EU law would still not be compliant with the Aarhus Convention. And so still some really strong resistance within the European institutions to actually allow environmental NGOs to challenge decisions adopted by European institutions and to hold decision makers accountable. So now we'll hear from Antoine Bailleux. So Antoine is a professor of EU law and legal theory at the University of Saint-Louis in Brussels. His research and practice cover the whole spectrum of EU constitutional law. His latest edited book is Le droit en transition, les clés juridiques d'une prospérité sans croissance. And he's also, of course, a lawyer, and he represented the Brussels Capital Region in the case before the Court of Justice of the EU. And so we'll hear Antoine talk about that recent ruling that was adopted on the 3rd of December by the Court of Justice of the EU. And so we were really hoping that the court was going to adopt the same approach that they did in the case brought by the cities that I had mentioned, brought by Paris, Brussels, and Madrid, in which they were given legal standing. Unfortunately, the court didn't follow that same approach and shut its doors once again to these stakeholders, the regions, even if these are public authorities which have a crucial role to play in the implementation of environmental law, but including in the implementation of decisions adopted by European institutions. So that is really disappointing, as it seems that the court doesn't really measure the extent to which allowing these stakeholders to enforce environmental legislation is crucial to have the right level of environmental protection. And this enforcement needs to happen both before national jurisdictions, but of course also before the EU courts to challenge decisions adopted by European institutions, which apply across the EU throughout the 27 member states. And so it is really disappointing, since it seems that judges from the General Court and the court still do not get the extent to which allowing environmental legislation from being enforced is crucial today, given the urgency of the situation. It's also super disappointing given the opinion that Advocate General Bobek had adopted, advising the court to provide legal standing to the region, highlighting the important role that regions have to play in the European project. But it's also super disappointing in terms of the quality, or rather the lack of quality of the ruling, and the motivation, or rather the lack of motivation from the court to adopt such an important ruling, shutting its doors to regions. Yeah, so Antoine, I'll give you the floor to take us through the background of the case and the ruling from the court. Thank you.
Okay, thank you very much, Anais, and thank you, ClientEarth, for organizing this very interesting event. Well, it's not an easy task, of course, for a lawyer to comment on a case that he was involved in. Well, I'll do my best, trying not to be too resentful, basically, of the court's judgment, because indeed I also was very amazed by what I think is a very weakly reasoned judgment. Maybe Capucine, yeah, thank you. So these are my slides that I think you can easily download from the website. So basically, a few words first on the legal framework. What you must understand is that we have three layers of norms here. You have, at the EU level, the active substance approval process. And in this particular case, it was an implementing regulation adopted in 2017 that for 5 years renewed the approval of glyphosate. It was not an easy decision. It was decided finally at appeal committee level. So it's in the comitology procedure. As you may know, you have first, well, the Commission must gather qualified majority support for its implementing decisions. In principle, at the level of committees, like the SCOPAF committee in this particular case, so civil servants basically of member states. In this particular case, it did not manage to obtain qualified majority supports, so it had to go to the appeal committee level of permanent representatives, or even sometimes ministers. And there, at the very end of the day, it managed to gather qualified majority support because of Germany's last-minute change of heart. Actually, it was even not Germany, but rather the German Minister for Agriculture that decided without actually Angela Merkel or the rest of the government knowing it. Anyway, so that's just the political story behind it. Then once you have your active substance approved, then as Anne said it, member states must still authorize products containing this active substance, because you don't just apply the active substance as such on your fields. They have to be mixed with coformulants, with synergists, all sorts of products or substances, sorry, to act as a product. In most countries, of course, today, glyphosate-based products continue to be authorized, although often with restrictions. For example, in Belgium, only glyphosate-based products for professionals are still allowed on the market. There is an exception, though, now in Luxembourg, where, as far as I can tell, all glyphosate-based products have been denied market access. And then in Belgium, well, it's a federal country, a bit complicated country, and the regions have competence, a lot of competence in the field of environment. And so based on that, the Brussels region has decided to prohibit the use of any glyphosate-based product as soon as 2060. And as you can imagine, quite logically, this ban was challenged by product authorization holders before the Belgian Council of State. Okay, so the case now. In 2017, the Brussels region decided to launch annulment proceedings before the EU General Courts for breach of the precautionary principle. I could have obviously take a lot of time explaining all the arguments we had in support of our claim for annulment, but this is not the topic today. Leave to intervene was granted to several environment associations, but also to the Walloon region. All these people were in support of the Brussels region, whereas several companies active in the pesticide sector asked for acting in support of the Commission. In February 2019, the General Courts decided that the Brussels region action was inadmissible because the Brussels region was not directly concerned. The thrust of the argument was basically that the Commission approval does not directly affect the exercise of the Brussels region's competence because, again, as Anne explained, you have between these two layers, you have the intermediate layer, of the products authorizations that are adopted at national level. So per se, the approval of the active substance doesn't do anything on Brussels, if I may say so, because it doesn't have any teeth per se until it hasn't been implemented or made real, made practical through national authorization, product authorizations. But then what we expected, honestly, we expected that it would be difficult, and we kind of expected that the General Courts would have a hard time basically reversing a long-standing case law regarding locus standi, including for regional entities. So this was not exactly a total surprise, but we wanted to appeal this case because, well, if a change had to come, it had to come from the Court of Justice. So we appealed and we elaborated a lot of arguments explaining why actually the Commission, the Brussels region was directly affected. And well, we were very happy to hear that Advocate General Bobek in July of this year agreed with us, considered that the Brussels region was directly concerned, and that the Commission approval was a regulatory act that does not entail implementing measures vis-à-vis Brussels. So basically, these are the two conditions, as Anne explained, that make the application admissible. However, as Anais and Anne already said, the judgment of the 3rd of December decided otherwise. The Brussels region was regarded as not directly concerned, hence the case was declared inadmissible. Okay, I will not remind you of this locus standi test. Anne just did it, so I'll just skip it and go directly to our position, our line of arguments. Basically, there are two main limbs here. The first is the Aarhus Convention. We argued that the 263 TFEU requirements had to be read in light of the Aarhus Convention, and that includes, of course, the Compliance Committee findings. Why? For two reasons, basically. First, because in general, it is a fact that primary law must be read in the light of subsequent international treaties ratified by the EU and all the member states. Who says that? Not me, but the Vienna Convention on the Law of Treaties, Article 31.3c of the Vienna Convention on the Law of Treaties, which is customary international law, basically says that you have to take into account all the norms, all the treaties, all the international legal norms that are relevant in the relations between the parties when you interpret a treaty that has been ratified by both these parties. So in this case, it was very clear to me and to international lawyers also that primary law, and including here Article 263, had to be interpreted in the light of this the Aarhus Convention, and that was also borne out by precedents. There are not many, but there are a few and very important cases, like the Whiteman case on Brexit, the Intel case in competition law, and so on and so forth, where the court does interpret primary law in the light of international law. Now, I read in an op-ed, and I think the author of the op-ed is now listening to us, that this was a bit different because in these cases, the provision referred to by the court was not a treaty provision. It was international customary law. Now, that is true, but I don't see the relevance really of this difference. I don't see why it would be okay for the Court of Justice to interpret primary law in the light of international customary law, but not in the light of treaties that have been ratified by all the member states and the EU itself. I mean, there's no precedence in terms of international law between customary law and treaty law. So to me, it's clear that they had to do so. And beyond that question, the general question, in the very case of the Aarhus Convention, there is another very important point to be made. It's that ruling otherwise would create an inconsistency with the court's case law regarding the implementation of Article 9 of the Aarhus Convention by national courts. As Anna already reminded us, in the Slovak Bear case, for example, the courts clearly said that national courts had to interpret their own procedural rules in the light of Article 9 of the Aarhus Convention. This duty of consistent interpretation. Now, why on earth should national courts do this and not the Court of Justice? There is not the slightest legal argument adduced by the Court of Justice in support of this distinguishing, and I can't think of any. Now, the general courts didn't argue with that. It actually it raised a good point, I think, valid point. The question was to them whether or not the Brussels region was a member of the public within the meaning of Article 9, well, of Article 2 actually of the Aarhus Convention. Basically, its underlying premise was that it was not possible because the Brussels region was a public authority. So it cannot be both. These would be mutually exclusive categories. Now, on appeal, we argued differently, as you can imagine. We argued that the Brussels region was a member of the public, and we put forward three different lines of argument. The first one is a literal argument. If you look at Article 2 of the Aarhus Convention, it simply says that the public is one or more natural or legal persons, and in accordance with national legislation or practice, their associations, organizations, or groups. Well, by that definition, there is no doubt that the Brussels region is part of the public. It is a legal person. That's it. Second argument, it's a teleological argument. And the rationale behind the Aarhus Convention is, of course, to reduce asymmetry situations where some people have information and decision-making power, some entities, let's say, and some others do not. So our argument was to say, well, you can, in some instances, be a public authority, and in some other instances, be a member of the public. There's nothing impossible in that. There's nothing irreconcilable in that. And we also drew on the compliance committee comments or observations regarding ClientEarth filing. And ClientEarth, in its statement, said basically that the Aarhus regulation fails to grant to individuals or entities other than NGOs, such as regional and municipal authorities, access to internal review. And the compliance committee never said, well, yes, but that may be true for NGOs, but you know what, regional and municipal authorities, they do not fall within the scope of the Aarhus Convention. It didn't say so. So again, why would the court decide that? And the last argument, of course, is that if you were to rule otherwise, if you were to consider that the Brussels region in this case cannot avail itself of the Aarhus Convention, then you would create a discrimination between non-state public actors and private actors. Okay, so basically you would have the privileged applicants, the states, you would have the private actors that can avail themselves of the Aarhus Convention, and then in between you would have cities, regions, and that kind of non-state public entities that would be left without any remedy. Advocate Joel Bobek considered that in this particular case, the Brussels region could not be a member of the public because it had acted as a public authority. So it didn't pronounce on whether or not per se these two categories were mutually exclusive, but it was his view that in considering that the Brussels region in the glyphosate case had acted as a public authority, it could not be in the same case regarded as a member of the public. However, he argued that he agreed that the consequence was that the Brussels region falls essentially between two stools, as I said, not a privileged applicant, but also not a member of the public within the Aarhus Convention. He also argued that the preliminary reference route was not well suited in a case like this one, and that I think he has a very good point here. He basically says, well, the problem with the preliminary reference route is that it directly leads you to the Court of Justice. The Court of Justice will only rule on issues of law, not issues of facts, and you only have one round of submissions. All the parties at the same time handing their submissions to the Court of Justice, and then that's it. You have an oral hearing, and then that's over. So it's not a good procedural route to really discuss in depth technical cases, like, for example, the glyphosate case. So basically, he suggested relaxing the locus standi test, and suggested more specifically endorsing the General Court's position in the Vlaamse West case, basically saying a region must be regarded as being directly affected and actually also individually concerned when the act that it seeks to annul in a way prevents that entity from exercising its own normative constitutional powers as it sees fit. The Court of Justice didn't bother to go that far. The Court of Justice simply said, well, international agreements cannot prevail over EU primary law. Therefore, basically, Article 9 of the Aarhus Convention cannot have the effect of modifying the conditions of admissibility of actions for annulment laid down in the 4th paragraph of Article 263 TFEU. This is really weak. I mean, first, it pretends that what we are arguing is putting international law on top of EU primary law. We've never said that. It's not a hierarchical approach that should be adopted here. It's simply the idea that you must, as much as possible, take into account the context of the EU treaties. And the context, well, it also consists of treaties that have been adopted by the EU and other member states. So we're just trying to reconcile two international treaty norms, not decide that one has primacy over the other. Secondly, I think the Court of Justice here is hiding behind the myth of the merger between the interpretation and the text. What do I mean by that? It basically says, well, what you are asking us to do is to amend Article 263. We are just asking, just like ClientEarth said, asking for the Court of Justice to revise its own case law, its own interpretation. And so it's pretending basically that its interpretation sticks to the letter of the law and that there is no possible other interpretation of these conditions. I mean, who honestly can buy that? Finally, and that's for me the most problematic part with this part of the reasoning, there is a total ignorance of our argument based on the Vienna Convention on the Law of Treaties. total ignorance. There's not a single line on this, and of its own case law. Nothing at all. The court does not even bother to explain this. So yeah, this is a very disappointing part of the judgment. Now, moving on then to the core of the problem, the direct concern requirements. Again, as Anne said, this test, you know it now, in order for an entity to show that it has been directly concerned, basically it must show that its legal situation has been directly affected by the act at stake. And the Commission's overall position, quite understandably, was to say, well, actually, in these cases, there are intermediate rules. You have the federal product authorization. So as I said, the approval of the glyphosate per se doesn't alter the legal situation of the Brussels region. We begged to defer, and we said that actually the Brussels region's legal situation was directly impacted in 4 different ways. The first one was that because the regulation preserves the validity of the current product authorizations, it also undermines the effectiveness of the ban, and so on and so forth. But what do I mean by because it preserves the validity of current product authorizations? You should simply imagine what would happen if the Commission had decided not to renew the approval. Well, the consequence would have had to be that all the authorizations, all the current authorizations would have to be immediately withdrawn. Because it renewed this approval, all the authorizations for products that were valid at the time, that were enforced, could continue to be enforced and to run until their expiry date, usually 1 year after the end of the old approval document. So basically, this fact, that's just a fact, okay, had the effect of undermining the effectiveness of the Brussels region ban, because it meant that these products could continue to be sold over the counter in Brussels region shops for a year. Second, it kept the Council of State proceedings against the 2016 ban alive, because otherwise the applicants would have lost any interest in the case, because, well, the glyphosate would have been prohibited over all the EU. And because of this decision, well, the Council of State proceedings could remain alive. And thirdly, it also questioned the constitutionality of the ban. In 2019, indeed, the Belgian Constitutional Court, in an obiter dictum, basically said that it might be problematic for a region to completely ban a class of products because it basically hollows out the competence of the federal state to decide whether or not specific products can be marketed. So it's a problem, an internal problem here of Belgium, but it is caused here by the decision to renew the approval. The Advocate General followed us, whereas the Court of Justice and General Courts stopped at the very premise of our reasoning. They said, no, it is not true that the regulation preserves the validity of the current product authorizations, because once you have had the approval renewed, new applications for reauthorizations must be filed. Now, I think here, both the General Court and certainly the Court of Justice have on purpose decided to not understand the points. Of course, it is true that at some point, once the approval has been renewed, all the industry basically has to file for reauthorization of their products. That's just because the authorizations can only last for one more year after the expiry of the earlier approval. So yeah, they have to do that. But in the meantime, it's a simple fact that the regulation preserves the validity of the current product authorization. So we explained that at length in all our submissions, and yet the Court of Justice decided not to understand the point. And also, quite strikingly and surprisingly and disappointingly, the Court of Justice said, yes, by the way, the fact that it kept the Council of State proceedings alive, I will not even look at this argument because it was not raised at the outset of the judgment, in limine litis. The plea was not raised at the outset of the case, in the first instance level. But then again, it doesn't make any sense from a procedural point of view. I mean, those of you who are lawyers, well, you know that a plea is something that you will express in support of a demand. In this case, for example, to demand that the regulation would be annulled. That is a plea. What we did there was simply to counter-argue what the Commission said. So the Commission said, no, you like direct concern. We said, no, this is not true, and this is why and why and why. This is not a plea. So this is, again, I think, a procedural, I mean, this is a mistake to me from the Court of Justice. Then the second argument was that the regulation also questions, I wouldn't say per se is incompatible, but it questions the validity of the ban also as a matter of EU law. Why? Well, because, of course, as you may know, the renewal was based on the finding that at least one product, not just the substance here, but one product containing glyphosate, and in that case it was a Monsanto product, complied with all the health and environment requirements. So you could argue that at least regarding that specific product that had received a green light from the Commission, member states and also regions are no longer at liberty to decide to ban it. Because doing it otherwise would basically deprive the regulation from any effectiveness. This analysis was borne out by the Commission's critical observations sent to the Brussels region, saying, well, there might be a problem here with what you're doing. We said that to the court. We also said that the risk was materialized by pending Council of State proceedings, and we also established a link with the direct concern test in the Ville de Paris case, okay, which was exactly that, okay, the fact that there might be a case, and therefore you are directly concerned. Here, there was a case. Now, I love this. The General Court said, well, you know, even if this argument was grounded, these threats have actually not dissuaded the Brussels region from pursuing its prohibition policy. So what are you complaining of? I mean, the Brussels region did it anyway. So it shows you that there was no actual effect on the way it decided to exercise its competence. Now, on appeal, we said, yes, but you know, that's a political decision made by the Brussels region for all sorts of reasons, which may also not be entirely legal. Okay, there may be other considerations than just the law to go forward. So this was a matter of fact, not of law. And the Court of Justice, again, decided not to understand the point. It said, you know, the possible political effects of the measure are irrelevant. But we know this was exactly our point, to say that the political effects, the fact that eventually the Brussels region had decided to go forward with the ban, was irrelevant. Anyway, the court decided not to understand. Again, we said, well, there is a contradiction with the Ville de Paris case. Again, that doesn't make the ruling unlawful, the Court of Justice said. Okay, I never said the opposite, but what we said was that then, of course, the General Court had to reason, had to explain why it was different and how it reconciled its two precedents. And finally, this is probably the least comprehensible part of the judgment. The court said, in any case, the legality of the decree of the ban of the 2016 cannot in any event be affected by the act at issue, since that act was adopted after the date of adoption of that decree. So that, for me, is a first bachelor mistake. Basically, the court says, well, you know what? The primacy of EU law stops when EU law is posterior to the internal act. So, I mean, that to me really doesn't make any sense. Of course, that if there is a problem in terms of compatibility between the ban of the Brussels region and the regulation of the Commission, of course, that compatibility must be resolved. And that means that it either annulling the act of the Brussels region or setting it aside, as you all know, the case law of the Court of Justice. So again, I mean, this cannot be reconciled with any other judgment of the Court of Justice, as far as I can tell. The third effect, I'll be a bit shorter on this, was basically that the regulation did impose directly an obligation on the Brussels region, because the Brussels region, as a matter of Belgian constitutional law, is involved in the decision of whether or not to authorize products. So it's not just the federal authority per se. Regions are associated in the process. I will not go into the details of this. I can get back to that if you want. I don't want to take too much time. Simply, the Court of Justice said, yes, but that obligation comes from the Belgians' internal constitutional setup. Now, again, this is contrary to consistent case law of the Court of Justice, where it is clear that the direct concern test doesn't look at the reason why the applicant is affected. It only looks at whether or not it is affected and directly affected. If it is affected because of a specific market power, because it has a contract, because it has an intellectual property right, or because of a constitutional prerogative, is completely irrelevant. Again, the Court of Justice here didn't convince me, to say the least. Finally, and I think this is an important point, we also argued that the regulation, of course, reduces the Brussels regions and more generally Belgians and all the other member states' margin of appreciation regarding the authorizations of products containing glyphosate. And this is related to the system of authorization of products, which works through geographic zones. For example, Belgium is with Germany and other countries. So it means that once the company has received the approval of, has been notified of the approval of the glyphosate, it can then, for one product, ask for the authorization of that product in any country of the zone. For example, Germany. And as soon as Germany says, okay, this is fine, this product is in compliance with the environmental and health requirements of the regulation, then in principle, all the member states have to accept the same product. So there is a mutual recognition principle. Now, it is true that there is an exception, though, which says that you can refuse it. Belgium, for example, can refuse the product authorized by Germany if, due to its specific environmental or agricultural circumstances, en raison de ses caractéristiques environnementales ou agricoles particulières, it has substantiated reasons to consider that the product in question still poses an unacceptable risk to human or animal health or the environment. Now, our argument here was to say, well, this is not what the Court of Justice usually calls margin of appreciation. Actually, what Belgium has to prove here is that there are specific questions or features of the soil in Belgium or of climate in Belgium that warrant for extra care compared to Germany, for example. But that is very difficult, of course, to prove, especially regarding countries that are in the same zone. I mean, they have been put in the same zone for specific reasons, because in principle, they have the same climatic and pedologic characteristics. So this is not margin of appreciation. The General Court said, yes, it is margin of appreciation without any explanation. We re-explained on appeal that it was inconsistent with the Court of Justice definition of margin of appreciation, which entails the power for states to decide the level of environmental protection. And Belgium should be allowed to have a more stringent level of protection of the environment than Germany, for example. And the Court of Justice again said, yeah, it is margin of appreciation, but without any explanation. Again, to me, it's inconsistent with long-standing case law, but it has potentially far-reaching consequences, because on the other hand, it means that indeed it's good for Belgium to know and for all the states to know, well, actually, they can decide not to recognize product authorizations that have been recognized elsewhere just because they don't agree with the level of protection of the environment that has been established in that member state. I find it very strange in the light of the whole internal market underpinning of the regulation, pesticides regulation, but I mean, that's exactly what the Court of Justice is telling us. So that's in a way, that's good for the environment. So that's my conclusion. My conclusion is very short. I think, of course, it's a defeat for the Brussels region, but it's not just that. The problem is not just that. It's a great loss for effective judicial protection. No standing here for regional entities. It is a clear blow in the right to a fair trial, because I mean, we were not provided with an adequate reasoning from the court. And of course, obviously, also it is a defeat for the health and environment protection, because it means that the significant flaws that we had identified in the glyphosate assessment process will probably never be judicially reviewed. And so this is all very sad. So then what is the explanation for that judgment? I don't know, of course, and I probably don't want to know. But my realist take is probably that it was a thorny, delicate case that would be very time-consuming for the courts, both courts, to handle, and it's my view that for the moment the Court of Justice is very much concerned with its own productivity. It wants to be fast, which is good, of course, but I don't know. Sometimes, I mean, a case like this one, I think, should have deserved a grand chamber judgment and a proper reasoning. I'll stop there. Thank you.
Thanks a lot, Antoine. Thank you. We can. So I think we're going to take questions after Georgina's presentation, and then we can discuss. Really disappointing indeed, as I said previously. I just would like to take up on the fact that you mentioned Article 27 of the Vienna Convention on the Law of Treaties, which is really the provision we relied on throughout the discussions in relation to our case before the Aarhus Convention Complaints Committee. And we kept on recalling to the European Commission, which was representing the EU in our case, that Article 27 of the Vienna Convention really clearly provides that a state party to an international convention may not invoke its internal law and systems not to perform a treaty that they are party to. And and we've never got a reply actually to that point, never from the European Commission representing the EU. And it's true that it's really, really surprising the extent to which the court seems to, as well, kind of exempt itself sometimes from also complying with that rule. And also what is frustrating and surprising is that with these cases, it really seems or sound like a deaf dialogue, with the courts often misinterpreting our arguments. So your arguments in that case, but also our arguments, especially on the fact that we would ask for a treaty change. No, we are not asking for a treaty change. We are asking to the courts to slightly to make its case law and its interpretation of Article 263, paragraph 4, evolve, and also ensure that this jurisprudence, along with the EU judges, enter the 21st century and maybe get a bit closer to the society we live in, to the people, to the members of the public, to the NGOs, to the need, to the calls that are being made by civil society for a stronger environmental protection, which cannot happen again without strong enforcement of environmental legislations before the courts, including before the EU courts. So now we'll hear from Georgina Short. She is a senior business manager at C40 Cities Climate Leadership Group, a global network connecting 97 of the world's leading cities, taking ambitious climate action. And Georgina is currently co-leading a project on the potential of urban legal action. So Georgina, please cheer us up by telling us what the cities are already doing in order to ensure correct implementation of environmental legislations and what you may be envisaging in terms of litigation. Thank you.
Thanks, Anais. Can you hear me okay? Great. So thank you very much for the invitation to join you today, and thanks to Anne and Antoine for those fantastic presentations. I'm looking forward to the discussion after this. As Anais said, I am a senior business manager at C40. C40 Cities Climate Leadership Group is a little bit of a mouthful, so we generally go with C40. And I was formerly a lawyer myself, a corporate lawyer working in the City of London, but have now entirely switched into a new field of urban climate action, and have been working in the last few years for several organizations that focus on what city governments can do and also what national governments can do through urban-focused policies to tackle climate change. So at C40, the project that Anais mentioned that we've been working on this year is a project to scope the potential of urban legal action to tackle climate change and environmental issues. And before getting into the presentation, some brief disclaimers. Firstly, that I'm speaking on my own behalf as a member of C40 staff, but not specifically for any mayors or cities in our network, although I will of course mention cases that they have been involved in. And as you may expect, this is not so much a legal perspective as the previous presentations, but given we have some fantastic lawyers on the call to cover those presentations, I hope this will be a useful complement to that. So as Anais mentioned, I'm going to talk today about the role of cities to date in climate change and environmental related legal action, their rationale for involvement, more broadly, what their role can be in implementation and enforcement of environmental legislation, and also a few reflections on the case already referred to several times brought by the mayors of Paris, Brussels, and Madrid. Briefly though, as some of you may be less familiar with C40, as previously mentioned, we are a network of the world's greatest cities, which have a shared commitment to tackling climate change and realizing a green and just future for all. We have 97 member cities, which represent together over 750 million citizens and a quarter of the global economy. And the network was formed by mayors, for mayors. It is currently chaired by the mayor of Los Angeles, Mayor Eric Garcetti, and before that it was the mayor of Paris, Anne Hidalgo. And so really at the core of what we do and the sort of raison d'etre for C40 was to support mayors in their exchanges as they find solutions to the climate change problem, tackle it through their actions in cities, and sort of exchange those best practices between cities and try and apply them to different contexts around the world. And our work is now expanded from that core to encompass research, communications, advocacy, diplomacy, and lots of other work with cities. So just to give a brief flavor of very, very recent work, through our Deadline 2020 program, which you can see on the left slide there, we are supporting cities to each develop a climate action plan, which sets out how over the coming years they will deliver their fair share of greenhouse gas emissions reductions to keep global temperatures to the 1.5 degrees target of the Paris Agreement. And just Friday just gone, we announced how the climate action plans of 54 of our cities, when implemented over the next decade or so, should prevent at least 1.9 gigatons of greenhouse gas emissions from being released into the atmosphere. And that is equivalent to half of the combined annual emissions of the EU's 27 member states. Now, our ZEBRA partnership, that stands for Zero Emission Bus Rapid Deployment Accelerator Partnership. So ZEBRA is, again, a bit easier to say. That's a partnership with the ACCC. And last week, 15 bus manufacturers and investors have made public commitments to bring new e-bus products and financing to the market in Latin America, which we expect will lead to the deployment of over 3,000 e-buses in the next 2 years in Latin America. And finally then, I think quite relevant context for us all at the moment is clearly the COVID-19 crisis and the impacts of that, which are being felt around the world, including in cities. And in response to that, C40 Cities created a global mayoral task force through which they have been exchanging their solutions and ideas for both responding directly to the pandemic in the immediate term, and also in the longer term, looking at how to have an equitable and sustainable recovery from the pandemic. And so they have released this agenda, which sets out some of the measures that will be really critical to such a transition, including green job creation, investment in sustainable infrastructure, protecting safe public transport, and so on. And that agenda includes examples of what cities are doing already in this area, but also calls on other levels of government to also work towards a green and just recovery, and calls on national governments in particular to end fossil fuel subsidies. So turning to the legal project then in this year, so we wanted to look at what cities have been doing to play a role in legal action. We wanted to assess the global landscape of both actions already being pursued by cities and also actions which many of you will be familiar with being pursued by other actors, whether that's NGOs, civil society groups, youth plaintiffs and so on, to think about whether there's a role for cities there in the future. We also wanted to explore cities' perspectives in terms of their reasons for taking action, their particular interest areas or motivations, and any concerns they might feel about bringing legal action. And in carrying out our research, we worked with a number of leading legal organizations, including the Sabin Center for Climate Change Law in the US. And also we received some fantastic guidance from a number of ClientEarth colleagues. So thank you to all who were involved in that, helped us a lot. And with that, we have written a sort of report or a guidebook for cities who may be considering this or have not so much taken legal action in the past, to help them consider how it might be an avenue for them in future to break down, overcome barriers that they're facing to ambitious climate action. So we hope to bring that out early in the new year. And part of that was also to consider how strategic collective legal action, whether that's by several cities together or by cities combining with other stakeholders working in this area, could be a really, really powerful force as well. And we're now looking at where we might best be able to support cities that are interested in taking action driven by their priorities. So turning briefly back to the cases brought by the mayors of Paris and Madrid and Brussels against the European Commission, you can see highlighted on the slide here a couple of quotes from the mayor of Paris and the former mayor of Madrid at the time the case was being heard before the European Court of Justice, which highlight, I think, what we can see as one of the primary reasons why cities and indeed regions as well could play a strong role in such action, being the sort of levels of government very close to their citizens, understanding the issues citizens are facing and indeed already trying to help address them. And as such, being, as Manuela Carmena said, the main defenders of their causes. Looking briefly back to a more global perspective, this was clearly a milestone case in Europe, but not the only action being taken by cities. The US is clearly a key site for litigation, and cities are no exception in that. We have seen a number of states and cities in the US in recent years bringing cases against fossil fuel majors. We've also seen both states and cities together being involved in numerous suits which have been challenging the federal government, and most recently the Trump administration in relation to rollbacks of climate and environmental related legislation on issues such as energy efficiency standards, vehicle emission standards, pollution control from power plants, and so on. And then in another part of the world, in South Africa, we've seen Cape Town bringing a case against the Minister of Energy and the National Energy Regulator for South Africa. This was after a negotiation process through which Cape Town had sought a determination to be able to procure renewable energy from independent power producers, something which it currently doesn't have the right to do. It has to go to secure power through the national utility. And after the dialogue was unsuccessful, Cape Town decided to pursue the matter through the courts. And the case was heard in May this year, and the court directed the city to undertake further negotiations with the government. That was the outcome of the case directly. However, recent national announcements in South Africa and national sort of legislative amendments in process indicate that cities, the door may be open for cities to procure renewable energy or procure energy from different sources. And so it may well be that this case has contributed to this general policy shift in South Africa. Other significant cases in Europe worth mentioning, I'm here in France at the moment, where we've seen recently a case brought by the municipality of Grande-Sainte, excuse my pronunciation, which is a case against the French government for insufficient action on climate change. And you may be aware that case was heard last month, the Conseil d'État directed the French government to justify within the next 3 months its action and whether it is taking adequate action towards its own 2030 climate goals. And that I think was an interesting case in that the municipality in question is in a low-lying coastal area and really stressed its exposure to sea level rise and flooding in its rationale for bringing that case. We have also seen in the last few years the first climate change lawsuit against a fossil fuel company in France, which was brought by 14 French municipalities together with several leading NGOs against the French oil major Total. There's also a really interesting case involving the city of Krakow in Poland, which ClientEarth supported directly, which I may not have time to go into the details of that case now, but perhaps we could come back to it in the discussion. So then looking sort of back at what the rationale might be for cities to be involved in legal action and what specific role they might be able to play vis-a-vis other actors, I think it's clear that there's a legal question of their admissibility. In some cases, they may have standing where other actors may not. That's been sort of one of the key questions today. In other cases, that they may not have standing, and clearly that will be a first hurdle to cross. And it's also true that leaving aside the question of admissibility, there may be cases where another actor, such as an NGO or a group of youth plaintiffs, may be better suited or better placed to bring a case, but in other cases it may be that a city could really best represent perhaps its citizens' interests or the sort of legal issue at hand. So then, as well as representing citizens, we should be aware that the role of city governments relates to the fact that they are owners of major infrastructure and assets, that they are implementers of policy, both in terms of the policies that they themselves develop and in terms of their role in implementing EU legislation or across the world legislation at the national government level. They play a strong role in implementing that locally. And I think the case before the European Commission strongly sets out the situation that the cities of Paris, Madrid, and Brussels were facing in that instance, in that all three of those cities were taking action locally to combat air pollution, to try and improve air quality for their citizens, and then faced a situation where the potential regulation at the European Commission level was actually going to weaken the standards applicable to vehicles and therefore move things in completely opposite direction to what their own local efforts were trying to achieve. Of course, with the visibility of city governments and their role as elected officials and government leaders, what they do sends strong political and public messages and can make really big sort of headlines across the world, and that's therefore another strong reason for them to play a role. And in terms of what we heard from cities in terms of their rationale for taking action, I think a number of them were interested in very publicly demonstrating their climate leadership through such actions alongside the efforts that they are taking directly in their cities, but that they were willing to also publicly pursue efforts, whether that meant a challenge to government at another level or a challenge against corporate interests, for example. We often say that cities are on the front lines of climate change, meaning that they are already feeling the impacts of climate change and they are aware that they will increasingly continue to do so in future, and that will impact them in terms of the resilience efforts and the costs associated with that they will have to bear, and that citizens may directly bear if it affects their property as well. So really trying to address that, ensure that perhaps the actors most responsible for the costs of climate change are the ones that bear those costs rather than necessarily the city governments directly, has been a motivation in some cases. And also an awareness that if city governments don't take action, the citizens may well question their role as well as local governments if they are not seen to be taking affirmative action. And finally, in terms of scrutinizing legislation, we've talked about the case before the European Court of Justice, and we've also seen quite an established role in the US, particularly again, where states and cities have joined forces both to comment on draft legislation, and once legislation has been passed, to also challenge that legislation, including the challenges I mentioned to rollbacks to environmental legislation in recent years. So a couple of reflections then on the cases brought by the cities of Paris, Madrid, and Brussels. The first one, I think, speaks to a point I touched on earlier, which is really the power of collective action by cities or by regional governments. I think it was sent a very strong signal that the major capital cities of 3 European countries affected by this regulation were all standing together and bringing a challenge collectively. It's also, I think, very important that such cases should involve the public, given that they are representing citizens' interests at the end of the day. And in this case, you can see on the right-hand side here a snapshot of the petition that was created by the Mayor of Paris, Anne Hidalgo, in support of this action, which had signatories from mayors of 20 major European cities and also garnered over 130,000 signatures from the public. And given, as I think Anne touched on, the substance of the case earlier, which was very technical, relating to the ask to annul a specific part of a regulation relating to real driving emissions tests. Now, that could be quite difficult to convey, but ultimately the case is about air quality. It's about protecting citizens' health, as it is so directly impacted by air quality. And I think it's therefore very important to be able to translate the sort of import of such a case to the public. And although this case certainly did get important media attention, I think making sure that there's that public awareness where cities are, or indeed regions are, the defenders of their interests, that sort of message is spread more widely, could be beneficial and could indeed encourage city governments to take more action in future. In terms of the opportunities for a similar case, I certainly don't have the answers here. I would love to hear from the legal community about what we think is the opportunity here, especially in light of the case which Antoine discussed in detail, showing that standing is by no means guaranteed, indeed is still a really difficult hurdle for future cases. And indeed also bearing in mind the sort of specific technical details of this case, it will be very interesting to see what future cases could follow, but we do hope that there will be some. And finally then, in terms of looking more broadly outside of challenges to the European Commission directly through the court system as to the other roles that there may be for cities in implementing and enforcing environmental legislation. Clearly, they have their own critical role to play in policy and lawmaking that they have is within their own powers. And I think it's particularly interesting to bear this in mind where cities are now in many spheres trying to implement bold policies which may be untested, they may be new and ambitious, they may go beyond the level of ambition being set at the national level, and therefore they may be subject to legal challenge. And we see many examples of that around the world. And in terms of, particularly in the European context, there are ways for cities to engage directly with European legislation and regulation as it is under development, through participating in consultations held as part of that development, and engaging directly indeed with representatives of member states, MEPs, as well as, of course, advocating to their national governments when EU directives are being transposed into domestic law. We can see a potential scope for more sort of collective advocacy together with other stakeholders, where those stakeholders and groups like ClientEarth are already playing a fantastic role in commenting on and helping to shape the direction of such future law and policy. I think that could be particularly important where in areas that directly touch on city competency and indeed affect their citizens, such as is the case with air quality, and where there's often a strong counter lobby, as we know from industry, where it affects and restricts their activities. Cities can, of course, also consider whether to challenge a failure to adhere to or indeed implement EU law by national government, either by going through their national courts or perhaps even filing a complaint directly to the European Commission. And although we haven't seen that much city action in that sphere to date, I think it's really interesting to consider as a possible future avenue for more action. And one example is the critical cases brought by ClientEarth against the UK government, challenging their failure to tackle air pollution in line with EU legal obligations, where the Mayor of London was an interested party to one of those challenges and really supported that case through bringing statements and evidence to support ClientEarth's case. So then looking forward in the context of the EU's Green Deal and 2030 targets, it's undoubtedly the case that cities will play a key role in implementing those targets. It can't happen without them, and therefore there's perhaps a critical role for cities in ensuring that the right frameworks are in place to meet them. For example, if we think about the new renewable energy targets, which will come into force next year for 2030, scrutinising whether national governments have actually put the measures in place that will meet those targets, and indeed will also facilitate cities' role in assisting with such a clean energy transition. So in terms of what's next, an open question, I think we all know that the sort of global movement of climate legal action is continuing to grow, which is great news. More than 1,500 cases filed worldwide to date, including, as we know, an increasing number brought by youth plaintiffs, which is a really exciting movement to see. And with the number of city cases growing, we think this is only likely to continue as the climate emergency becomes indeed even more urgent than it is today. So we know that cities will continue their own ambitious climate action in their cities, and they will continue to call on the same from member states and from the EU community, as well as to national governments worldwide. And we hope indeed that they will continue to see legal action as an avenue to tackle the barriers to climate action that currently exist. But we certainly need all the great ideas of this legal community to think about specific cases and types of legal action that they can bring. Thank you, and I'm looking forward to the discussion.
Thanks a lot, Georgina, for this really interesting presentation. And it's really interesting and encouraging, actually, to see the central roles that cities are playing, and that is really in parallel, actions are being taken in parallel to what the environmental NGOs are doing as well, and seems more and more like a natural ally in this fight, it seems. So thanks a lot. So now I'll take some questions. I see, Antoine, that you've started to reply in written, but maybe I'll ask the question anyway, so it steers the discussion, if it's okay with you.
Sure. I'm sorry if I already started typing quickly answers. It's just not to have it some sort of a traffic jam here at on the questions side. But no. But I was still carefully listening to what Georgina said. Sorry, Georgina.
No, that's great. There aren't that many actually. So yeah, I think the first was from Arnaud Apothecaire. Hi, Arnaud. Could the Brussels region attack the national authorizations?
Yes. So yeah, my answer was yeah. Well, to me, yes. Of course they can. At some point, it's been discussed, but there might be a timing issue. Yeah. So because, as you may know, the glyphosate, the process for reapproval of glyphosate has restarted again for after 2022. So now, even if we start now a case in front of the Council of State of Belgium, it will take at least a year before the court decides to send a premier reference to the Court of Justice. Then you add another 18 months, and so it's going to be too late anyway. So I think it's going to be difficult.
Yeah. Also, I mean, what we want from an action taken before the Court of Justice of the EU is, of course, to have a decision that applies throughout the EU. If you take national cases, of course, it will only apply at the level of the countries, of course, and we've never seen such a coordinated action throughout all the member states at the same time to ensure the banning of a product, unfortunately. Anne, you can also intervene whenever you want. And there is another question from Shaba Kis. Hi, Shaba. From Justice and Environment. While in this specific case, so in the Brussels Capital Region case, it is to be supported that Brussels get legal standing. Can it if we treat state and municipal bodies as members of the public? So I think that Shaba meant, can it have negative repercussions, I guess, if we treat cities and regions as members of the public?
I would do probably Anne answer this question.
Yeah, I'm just trying to, at the moment, I'm trying to think about it, and I'm thinking more, coming to my mind that is there an echo? Can you hear me okay? Yeah. Okay. I'm more positive things are actually coming to my mind than negative things at the moment. For example, and the other pillars of the Aarhus Convention on access, the first one is on access to environmental information. It could be very helpful actually in some member states and even at EU level, the channel of information flowing between different organs of the state and different institutions is sometimes not very well established, and it could be helpful in some situations, I think, for certain public authorities to be able to have access to environmental information and use the convention in doing that. In terms of access to justice, I mean, from my point of view, I don't see a huge problem with it, because the case still has to be heard on its merits. I mean, it's just about having access to the procedure, and then obviously the court has to decide the case on its merits. So from my point of view, I think more access to procedures to be able to test whether specific decisions comply with environmental law is probably a good thing. However, having said that, I think that definitely it's something that I would have to do a bit more thinking on. Because perhaps in specific contexts, indeed, it could bring up some negative repercussions. But a good question, Shaba. Thank you.
I guess, sorry for the background noise. I don't have any control over that. I guess it's always the same question as well on whether we want really to open the access to the Court of Justice to the industry as well. So sometimes we don't have the choice. So we argue, of course, for the judges to open up and to change their interpretation of the criteria provided in the treaty. I think that the whole thing is to ensure that democratic values are upheld and to increase democracy as a whole. And so I don't think it's going to be possible to only fight to have only NGOs having access to the court and without ensuring that other entities, just as cities, regions, but also the industry get access to the court. So that's always a bit the same. Yeah, dilemma. I see Antoine wants to react.
Yeah, no, just a quick comment on this. My perspective is that actually the industry almost always has access. Because, for example, in the pesticides cases, it's obvious. I mean, they have a financial interest in it, and financial interests are always regarded as giving you an interest to access the court. And so the real fight here is to I think to restore some sort of balance with people who are acting not on behalf of their financial interest, but out of considerations of general interest, like NGOs.
Yeah. No, obviously that's our aim. But we cannot limit their access. I think every entity should have access, but it's true that the industry has way more access than NGOs and cities already, generally, including before the Court of Justice of the EU. Another question was, do you think on the basis of this ruling, it is likely that the court will quash the first instance judgment in Ville de Paris?
Yeah, well, I answered based on our prior conversation together. It seems, and indeed I checked, that the Commission didn't appeal on that specific point of the judgment on the admissibility question. So it will remain as it stands, with again the problem of consistency. I guess the Commission probably had accepted basically this new this more flexible approach. And so, well, it's such a it's such a shame that the Court of Justice now is basically saying no, but we haven't yet pronounced on this, and you should not consider this as the law.
Just to add, I mean, I think there's always a question of whether the court could take on this question ex officio, and I think it's probably possible, but hopefully they won't do that. But there's also, just to come back to what you were saying actually when you presented your case, Antoine, in terms of it's probably a good thing for the environment that the court found that you weren't directly concerned in some ways, because it means that you do have the regulatory powers to regulate the use of glyphosate, and there's the same sort of counter argument in terms of the city's case, in that I think the Commission probably accepted then that the cities don't have the right to regulate the circulation of Euro 6 cars, which it's a shame that there has to be this payoff in order to have access to the court, So yeah, that's just a comment on that.
Yeah, we try to be very careful in our wording, saying, well, what we're doing is not unlawful, but it might be. I mean, it might be caused to a lawsuit, and it might fragilize, let's say, our legal situation. But yes, we had to really walk a fine line, and yes, I agree with you.
Thank you. Another question from Estelle Brosset to Antoine. So that's a more technical one. So what is your point of view about Grano-Salus case? And then, so she points out to the relevant part of the ruling, which says that, shall I read that? So, la Cour a itérativement jugé qu'aux fins d'apprécier si un acte réglementaire comporte des mesures d'exécution, il y a lieu de s'attacher à la position de la personne invoquant le droit de recours au titre de l'article 263, paragraphe 4. Il est donc sans pertinence de savoir si l'acte en question comporte des mesures d'exécution à l'égard d'autres justiciables.
Yes, so indeed, we relied on this case. This is related to the second condition that I haven't really dwelled on because the Court of Justice didn't even get there. But so it's indeed a question of whether a regulatory act that does not entail implementing measures should be regarded in general, not entailing any implementing measure, or vis-a-vis the applicant. And indeed, it's great that the General Court said that in this case. And this is what we argued. We said, yes, well, it may be true that the approval by itself calls for implementing measures for the industry, because the industry cannot do anything with just the approval of the glyphosate. It needs the authorization products. But that has nothing to do with the situation of Brussels. Brussels is not the industry, and Brussels has its own legal position, and that legal position is affected. So yes, I think it's great. My fear is what is going to remain of that judgment if the regulation, the Aarhus regulation, is amended the way Anne just explained it. That is the new regulation basically would say that you can the internal review procedure would only be open if there is no, what is it again? If there is no explicit implementing measure provided for in the Act. But then there is not this, I mean, there's a restriction regarding the person vis-a-vis which the implementing measure is taken disappears. So here we would go back to a more general prohibition or condition, wider condition, which again would be problematic. And of course, it's not exactly the same. Here it's for internal review, but still it's a shame because it's different. I mean, if the person, if the implementing measure doesn't concern the person that seeks to annul the act, well, that means that this person will not necessarily have standing at national level to fight the implementing measure and then go to the Court of Justice through the primary reference procedure. So let's hope that this parts of the case law of the judgment will remain.
Yeah, I think from our point of view, it's still, this is very helpful, I think, in terms of looking at the situation of a consumer organization. It doesn't really answer the question for us on how the court will assess the matter of implementing measures from the point of view of an environmental NGO. And so we still do have some concerns on how the court would interpret that. But yeah, indeed, I think this is definitely moving in the right direction in terms of clarifying that it has to be kind of assessed from the point of view of the applicant.
And I don't remember the Commission fighting this in our case. I don't think that they resisted this.
Okay.
No, of course, and in this case, just to say, the court does go on to say, though, that the applicants weren't directly concerned because of indeed because of they were directly concerned by the national measure authorizing the plant protection product. So they were in the end they were in the same situation as the region of Brussels. Mm-hmm.
One point made by Peter Oliver. So I'll just read the comment. Of course, I welcome the idea that public authorities should have broader standing to enforce environmental law, but even the Aarhus Compliance Committee, of which I am a member, has stated in the HS2 case, found that they cannot be members of the public for the purpose of the convention. So disagreement on that point.
No, but well, yes, I remember discussing with Anais and others the relevance or the necessity of trying to convince the court that well, still, in spite of that precedent, the Brussels region could be regarded as a member of the public. Well, I thought that maybe the Commission or even the court would not see that precedent, would not know it. Considering that it doesn't seem to know very much about the Commission Compliance Committee findings, or to care very much about them. And well, to that extent, I was right. No one flagged it up. So it was like, well, maybe we're going to win, and the Court of Justice will adopt a more protective or generous, let's say, conception of what member of the public means. But no, it did not, for other reasons, sadly.
I actually think that one positive impact of that case, if we look at it from a positive angle, is that at least now, as well, the findings of the Aarhus Convention compliance committees becoming part of the discussion before the courts, and are also relied on by advocate generals at the court, which is definitely a progress, because it wasn't the case before, and we started to, ClientEarth, rely on the findings of the Aarhus Convention compliance committees in our cases before the court as well. And they first started to rely on the guide, on the implementing guide of the Aarhus Convention. I think it was in one of the opinions of an advocate general as well, and in some rulings as well from the court. And finally, now we really have references to the findings of the Aarhus Convention Compliance Committee, which is a great thing, because it is as well, I mean, an authoritative source of interpretation of the provisions of the Aarhus Convention. So I think it's great that they are becoming part of the discussion before the Court of Justice. Of course, we hope that they are going to be interpreted in a positive manner in the future. I don't see any other question in the chat. So we are 4 minutes to the end. So maybe Antoine, as a follow-up question, I think also what is interesting in that case is we clearly saw that there is a divide within the court. So clearly here, the Advocate General Bobek has taken a positive, a position advising the court to give legal standing to the region. The judges haven't followed it. Can we interpret that as a positive sign, as also future discussions within the court? And how can we interpret or what conclusion can we draw from that divide within the court, maybe for future rulings?
Yeah, it's a difficult question. A few things. First, of course, I guess it's always easier for an advocate general to take that kind of position than for the court, considering that, of course, what he says doesn't have any legal consequence. Also, Advocate General Bobek has already written a number of opinions where he advocates for an opening up, let's say, of the standing in front of the court. So it was not completely a surprise. But interestingly, it's a bit early to tell, but we have now also cases in front of the Belgian Council of State regarding the emergency authorizations granted regarding neonicotinoids. And so far, we have the support of the Advocate General in front of the Council of State, but not of the court. So far, it's not over. But again, we seem to have the same kind of divide. And this makes me wonder why. I mean, is it just because of these consequences? Like I said, of course, these are rulings that, especially on the merits, that have potentially huge impact in economic impact. and also on biodiversity, of course. So they might be more afraid. But what I most resent probably is the decision not to make this case a grand chamber judgment. I think it deserved it, not just because of the question that was behind it, the glyphosate, but because we need now a landmark judgment of the Court of Justice on this question, definitely. And so once we knew that it would be a chamber judgment, I was a bit more confident that we would win, because it was less likely that they would overturn or significantly alter the earlier case law. So yeah, that's what I can say.
No, thank you. I see a comment and reminds us the situation with UPA case and nothing happened. True, although it was a very long time ago. And so I think that the overall context was not the same at the time, like really environmental protection, environmental destruction and degradation was not as high on the political agenda. And decision makers hopefully have understood, heard, and realized that there is a real urgency today to tackle these issues, and as well before the courts. So yeah, so let's hope that that advocate generals are more heard in the future.
If I just can add this, at the same time of the UPA case, you may remember there was also the Jegokere ruling of the General Court. And that was delivered by, notably, among the other judges, the president of the Court of Justice today, the Kundenarts. So, yeah, one might have expected this new approach to go up to the courts with him, but no, apparently not.
Okay, maybe one last question for Georgina. I think you touched upon it, and then we need to leave. It's going to be the end, sorry, but you touched upon it obviously. But do you see in the overall work that you also coordinate within C40 and within that network, that cities see NGOs as a natural partner? And do you foresee in the future more actions taken up in collaboration with environmental NGOs?
Thanks, Anais. The short answer is yes, I think very much so. I think cities are very much looking for partners in their ambitious climate action, and NGOs, environmental NGOs are established in that arena already. And there's cities are looking, certainly our work with cities over the next year is looking to building a much broader coalition of city governments together with NGOs, together with youth, citizens, together with businesses, if they're interested in pursuing sustainable goals, to work towards these deals or these principles really of sort of securing a green and just future for everyone. So I think there will be a stronger role. That doesn't necessarily mean to say that their goals will always align. And I think it's also fair to say that environmental NGOs like ClientEarth have a role to play in holding city governments to account, just as they do with other levels of government as well. So great to have those pushes, but to the extent that cities can work together, where they're pursuing ambitious climate change goals together with NGOs, I think we should definitely look to see more of that in the future, and I hope that we will.
Thanks. Well, thank you all for really very interesting presentations. I think it gave a good picture of what the situation is today in relation to enforcement of environmental legislations by civil society, by members of the public, whatever that definition includes, from environmental NGOs, public authorities, cities, and regions. We hope that the court is going to uphold the General Court's ruling in the city's case, and I think it would be good for the EU judges as well to know everything that is happening also before the national courts, and we see more and more environmental legislation taken as seriously by lots of judges at national level and adopting ambitious ruling and contributing to protecting our environment through litigation. Your presentations have also unfortunately highlighted as well the restrictions that still exist, the loopholes, including in the Aarhus regulation proposal from the European Commission. The discussion is still ongoing, and it's with the Council now, the Council of the EU, adopting its position, with the German presidency rushing the process, unfortunately, but we are waiting and expecting the advice from the Aarhus Convention Compliance Committee on actually the legislative proposal to revise the Aarhus regulation. And so we'll see what the Aarhus Convention Compliance Committee thinks of that proposal and whether it will finally bring the EU into compliance with the Aarhus Convention. So still lots of resistance to provide access to justice and to ensure that members of the public may hold decision makers accountable. But definitely what is encouraging is that cities and regions have really become crucial stakeholders, actors in this fight, along environmental NGOs around the world, not only in the EU, to ensure enforcement of this environmental legislation and a stronger protection of the environment. So thanks to all of you. Thanks to all the persons who attended the webinars and asked questions and made the discussion alive. And thank you. See you soon.